Good afternoon, everyone. Welcome to today's webinar, New FAFSA Policies for Homeless and Foster Youth. My name is Barbara Duffield, and I am Executive Director of SchoolHouse Connection. We are a national nonprofit organization working to overcome homelessness through education. We do policy advocacy at the state and federal level and engage in practical assistance in partnership with schools and communities. And we're very excited today to be joined by great partners at John Burton Advocates for Youth and the Juvenile Law Center, and I will let our presenters introduce themselves.
Great. Hi, my name is Debbie Raucher with John Burton Advocates for Youth. We're based in California, and we do work that focuses on improving the quality of life for a couple of populations, in particular, youth who have experienced homelessness or who are currently or formerly in foster care. We do that through state-level policy advocacy, support for policy implementation, and working on the ground with practitioners to develop new innovative practice solutions.
Great, thanks, Debbie. This is Jenny Pokempner from Juvenile Law Center. Juvenile Law Center does legal and policy advocacy on behalf of and with young people in the child welfare system and the juvenile justice system, and I focus on issues related to transition age youth.
Hi everyone, and my name is Jillian Sitjar, and I'm the Senior Higher Education Program Manager at SchoolHouse Connection. And before we get started, we just have a little bit of housekeeping. This webinar is being recorded and will be archived on our website. A copy of this PowerPoint is also in the handout section, and I just put a link in the chat section as well. You'll also get a copy of this along with the recording. And if you have any questions, please feel free to ask them in the question portion, and we'll stop twice during this presentation, once in the middle and then afterwards.
All right, so just a little bit about today's agenda. We are going to have a little bit of context in terms of just if you're on this webinar, you know that FAFSA matters for children and youth from foster care or who are experiencing homelessness. Just a little bit of context about that. And then the main show today is going over the FAFSA Simplification Act. So we'll take a broad overview. We'll look at some of the specific provisions for homeless and foster youth, the broader context of financial aid reform for all students, but that has a specific impact for children or for youth and from foster care or experiencing homelessness. Talk a little bit about what happens next in terms of the implementation and the broader reauthorization of the Higher Education Act. And then we also have some other very important new higher education policies that passed specifically for youth from foster care. And as Jillian mentioned, we'll have a couple times for Q&A. And of course, please enter your questions in the questions pane as well. So if we're looking at, again, the question of homelessness and foster care and FAFSA, we know that some form of post-secondary education is still necessary for jobs that pay to get out of poverty and afford housing, and also that higher education is associated with many other indicators of health and well-being. We're also very concerned because as we see across systems that the equity gaps shown by COVID-19 are only going to get worse if we're not very intentional and very proactive about helping our most marginalized and vulnerable young people successfully make the transition to higher education and through higher education. So all of that is true. At the same time, we know that homeless and foster youth need financial aid if they're going to pursue post-secondary education, and yet they face many, many barriers in completing the FAFSA.
And so as Barbara mentioned, homeless and foster youth face many barriers while completing the FAFSA. And this is actually supported by a report from the Government Accountability Office in 2016. This report highlights some of the barriers that this population face, including the annual re-verification process for homeless youth, extensive documentation, the inability to access federal supports, and limited academic preparation, family support, and awareness for these students pursuing college. And so we're really excited today to share some of these provisions that we're going to be talking about that's going to tackle some of these issues. And it's really important because now more than ever, COVID has created even more barriers. FAFSA numbers are down about 17% compared to last year, and the decline is even steeper for lower income communities. You can see from the chart here on this slide that FAFSA numbers from the last 2 years. We've also noticed an increase in challenges with institutions asking for more documentation. And we get this information by working with our own students and scholars and the liaisons that are calling us and sending us emails. We're also noticing other communication issues where financial aid offices have sent really long and complicated emails to students that are confusing and further prevents them from successfully filling out the FAFSA. And so we've created a few COVID-specific resources on our dedicated FAFSA page, which is at the end of these slides. Oops.
So the FAFSA Simplification Act is actually the name of the bill that has the higher ed provisions, the FAFSA pieces that we'll be talking about today. It was included, however, in a much longer bill. So if you were to click on that link, the Consolidated Appropriations Act of 2021, that bill is 5,593 pages long, and it is on page 2,672 that you'll find the FAFSA Simplification Act. I mention this because if you just were to Google FAFSA Simplification Act, you would probably end up at previous versions of the bill. It was introduced in 2019 and again separately in 2020, and what ended up passing, it looks a little bit different. But was part of this broad set of reforms that Congress got to the finish line at the end of last year. Also very important to note is that the changes are effective as of July 2023, and no, that's not a typo, that's when it goes into effect. The same thing happened last time Congress changed the FAFSA. It was changed in 2007 and went into effect in 2009. It takes a while, particularly when there's this number of changes to revise. But they will be reflected in the FAFSA that's available to be completed on October 1st, 2022. So that October 1st, 2022 FAFSA will be where you'll see these changes. And we know that it seems like a long ways away, but first of all, this is good news we have to share, and we all need good news these days. Second of all, it's not too early to begin to plan for implementing this and for determining where are the areas that we're still going to need good federal guidance. We learned in the last round that even if the guidance wasn't heeded, even if it wasn't perfect, it was still really important in the application and verification guide to have the guidance flesh out items where the statute didn't give specific information. So as we think about implementation and how we're going to make this law work the best for young people, it's not too early to start talking about it. And then the last piece about why we're talking about this now is that some of the biggest changes, the most welcome changes, actually come from current guidance. Congress essentially took the federal guidance, some of it that's in the current AVG, and put it into the statute. So there's nothing to stop institutions from doing what the law says now, even if it's not formally required. Next slide, please. So we're going to go through the next couple of slides and focus specifically on the provisions for homeless and foster youth, and then talk about some of the broader pieces. So this, I would argue, is maybe one of the most welcome and most exciting changes, which is that the status of homeless and foster youth does not now need to be redetermined every single year. As you know, on the current FAFSA, for at least for unaccompanied homeless youth, it's something that it has to be determined on an annual basis every time they complete the FAFSA. So we have a lot of young people who find themselves having to track down documents, having to tell their stories over and over again. It's re-traumatizing for them. It's hard for them to find the paperwork, and it's just one more barrier that gets in the way every single year. Under the new law, students who are from foster care or in foster care or unaccompanied homeless youth, once they're determined to have that status, they're presumed to be independent for each subsequent year at the same institution, unless the student informs the institution that their circumstances have changed, or the institution has specific conflicting information about the student's independence and has informed the student of that information. So this is big. This means that our young people who have this status can continue every single year, not have to go through all of these processes unless their circumstances really do change, or unless the institution has specific conflicting information. Next slide, please. Also, the law states that these determinations for youth from foster care and homeless unaccompanied youth must be made as quickly as practicable. So again, the problem on the ground were the delays in determination that caused delays in aid that created more financial hardship and put youth at risk of dropping out. So under the new statute, determinations of homeless and foster youth must be made as quickly as practicable. They may be made as early as the year before the award year that the student submits the application, and they must not be made any later than during the award year for which the student initially submits the application. So this too, we know, will be very helpful so our students don't face additional challenges while these determinations are being made. Next slide. Another big win here is that the list of officials and programs who are authorized to determine unaccompanied homeless youth status is broadened. So again, under current law, it's the McKinney-Vento liaison, director or designee of a HUD-funded program, director or designee of a Runaway and Homeless Youth Act funded program, or the financial aid administrator. And in practice, the challenge is that many youth experiencing homelessness receive services from many others who may not be HUD or RHYA funded. Also, young people may not know the funding stream of the program that helped them. So there was really a need to have a broader list of who's authorized to make this verification. So under the new statute, the parties who are authorized, again, McKinney-Vento liaisons, also the director or designee, and you can read the language here, an emergency or transitional shelter, street outreach, homeless youth drop-in, or other programs serving homeless individuals. So a much broader category. Also added specifically is the director or designee of a program funded under TRIO or Gear Up. Also very important partners in serving youth who are experiencing homelessness and from foster care. And also added to the statute, not just financial aid administrator, but a financial aid administrator at another institution who previously made a determination. So this broadening of the authorities for determination also will make it easier for young people. Another important piece, and this is one of the pieces, as I mentioned earlier, that is essentially very, very similar to what is in existing guidance. And the hyperlink there is to the existing guidance, which is that financial aid administrators are required to accept these homeless youth determinations from authorized parties. In practice, we've seen that didn't always happen. There was not necessarily the deference to those parties, and even the guidance wasn't always followed. So again, the guidance now is in the law. And what the law says is that financial aid administrators have to consider and accept as sufficient documentation from one of those authorized parties, unless there's documented conflicting information, and also goes on to say that the documentation from the authorized entities can include a phone call, written statement, or verifiable electronic match. Obviously, the verifiable electronic match is speaking to youth from foster care more than it is for youth who are experiencing homelessness. But again, it's great to have in the statute a very clear statement that the financial aid administrators do need to accept these determinations. Also, for youth who cannot get determinations from other authorities, the law now says that financial aid administrators have to make those determinations. So again, very similar to existing guidance where the AVG says that for youth who don't have and can't obtain the determination from a third party that's listed in the law, the financial aid administrator is required to do it and is required to use the actual definition of homelessness. That's in guidance, but that also has often been overlooked. And as a result, young people, again, struggle with making the case, often getting referred to professional judgment process, being asked about the reasons for their homelessness as opposed to whether they meet the definitions. So under the new law, the determinations must be that the determinations made by financial aid administrators must be based on a written statement from or a documented interview with a student that confirms that they are an unaccompanied homeless youth or unaccompanied, at risk, and self-supporting. And also the law states that that determination from the financial aid administrator must be made independent from the reasons that the student is unaccompanied or unaccompanied, at risk, and self-supporting. this really gets at the status of meeting the definition of homeless and unaccompanied, as opposed to judgment about why a young person is in that particular situation. And I'm going to turn it over now to Debbie to talk more about some of the foster youth provisions.
Great, thanks so much. So in terms of the foster youth provisions, largely what the bill does is broadens the list of who can verify that a student meets the qualifications for independent status, meaning they were in foster care at some point after their 13th birthday. So if an institution requires documentation for foster care youth, and I'll just mention that there's actually nothing in the law that requires an institution from verifying this status, but if they do request verification, they have to accept documentation from this list of folks you see here on the screen. So a court order or official state documentation, a documented phone call or written statement, or a verifiable electronic data match from a state or county or tribal agency, a Medicaid agency, or a foster care placing agency. Or a documented phone call or written statement from the attorney, guardian ad litem, CASA, or verification of eligibility for an education and training voucher. So the great thing about this is that we know that getting this verification was a big barrier for a lot of foster youth, because a lot of times, if a youth exited foster care, say at age 14, and now they're 20 years old, they might not have contact or know how to get in touch with their social worker or somebody with the state or county agency. So this gives them a longer list of folks that they can get that verification from. And if they've already been verified for a Chafee ETV voucher, then the school doesn't need to get any additional verification at all. Just knowing that they were verified for that will serve as adequate documentation. If we move on, so the provisional independent student status. So this is kind of a new thing. We know that while many students will qualify under one of these criteria that we're talking about, either they were in foster care after the age of 13, or they're in a legal guardianship, or they qualify as an unaccompanied homeless youth, there are going to be other students who really should be classified as independent, but don't necessarily meet one of those specific criteria. And so what students will be able to do under these new rules is complete the FAFSA as something called a provisional independent student. And that means that they think that they are likely to qualify for independent status because of some sort of unusual circumstances. So the examples given are parental abandonment, abuse, neglect, if they've been legally granted asylum, or maybe their parents are incarcerated, but they've never had formally entered, say, the foster care system, and they're not currently homeless. And so in this circumstance, they can complete the FAFSA as a provisional independent student, which is great because it means they don't have to try to track down sometimes non-existent information about their parents to be able to complete their FAFSA. And then the administrators in the financial aid office have to notify the student if they indicate that they want to apply as a provisional independent student, what the process is for that student to then provide whatever verification the institution might require to make that determination if they do in fact qualify as an independent student. There's also requirements that the institutions have to make a final status determination as soon as practicable after all the documentation is received. And any student who receives this kind of dependency adjustment, so they're given this independent student status outside of the specified criteria on the FAFSA, is assumed to maintain independent status for subsequent years at the same institution, unless the student tells the school that there's been some sort of change in circumstance or the institution has some sort of conflicting information. So similar to with the foster and homeless student status, once this is obtained, it doesn't need to be renewed every year. And some clarifications about the provisional independent status. So I mentioned that this is a separate thing than the unaccompanied homeless youth criteria and the foster youth criteria. And in terms of the young people that we may be serving, we know that there's a lot of overlap into these different categories in terms of their life experience. But in terms of the FAFSA, this provisional independent status is different and distinct from the homeless and foster care provisions. And so why that's important to understand is that for homeless and former foster youth, financial aid administrators must make a determination according to the law. So there is no room for professional judgment. If you were in foster care after the age of 13, you're an independent student. If you have verification from one of those people listed that Barbara talked about, say you're McKinney-Vento liaison, that you're an unaccompanied homeless youth, you get independent status. There's no gray area around that. Whereas for this provisional independent status, this is something where there's going to be quite a lot of judgment that financial aid administrators are going to be making to determine if somebody can qualify as independent even when they don't meet the foster youth or homeless youth criteria. So this distinction is going to be really important to make clear both to financial aid offices, students themselves, counselors, and other advocates, because we don't want anybody thinking that they can deny somebody independent status who meets the legal criteria as a foster youth or unaccompanied homeless youth because they have some personal judgment around it. That professional judgment piece only applies when you don't fall into one of those categories. And then I'll just say a couple of words to close out this section about the data requirements. So one of the challenges that I think those of us in the advocacy and policy world have always had is that it's hard to know where change needs to happen when we don't have access to good information about how the current system is working. And we also know that it's been the way that the unaccompanied homeless youth question right now is framed on the FAFSA is incredibly confusing for anybody who's ever looked at that. It's pretty mind-bending to try to understand how to answer that question. It's like 3 different parts and all this kind of stuff. So what the bill requires for the new and improved FAFSA is that there's going to be a single simplified FAFSA question about homeless status that must be easily understood to identify an applicant who is an unaccompanied homeless youth or unaccompanied at risk of homelessness and self-supporting. Those are the legal definitions. And the question has to be distinct to those relating to an individual who does not have access to parental income due to an unusual circumstance. So that's, again, just the same thing I said a minute ago, that it's a distinct question from the professional judgment, provisional independent status. So that should make it a lot easier for these young people, hopefully, to respond to that question on the FAFSA. And then lastly, the Secretary of Education also has to publish data in a publicly accessible manner annually on the number of students who apply for financial aid who indicate that they're unaccompanied homeless youth or foster care youth. So this will be very helpful just to better understand the impact that these changes are having over time and where there might be ways to continue to improve access to financial aid. So I think I'm going to turn it back over to Jillian or Barbara to do some questions.
Great. This is Barbara, and just I've been going through the questions pane here. First of all, again, if we don't get to your question in this, we will follow up afterwards. But just to try to quickly answer some of the ones that have come up. What about a youth who's a couch surfer and may not necessarily be connected to a program? Very, very, very important, since this is the majority of youth who experience homelessness. They are staying with other people temporarily. This is where the provisions for financial aid administrators to make determinations based on the youth status as unaccompanied homeless youth come into play. So the law requiring the financial aid administrator to make those determinations for those young people is very, very important. Another question, this applies to McKinney-Vento doubled up college students as well. Yes, and that's a great point to clarification. Throughout this statute, the definition of homelessness and unaccompanied is exactly the same as McKinney-Vento Act. It references the McKinney-Vento Act definitions. So yes, it does apply to those who are doubled up, staying with other people. It says, most colleges have a McKinney-Vento form, or is the unaccompanied youth determination completed on the FAFSA? So the FAFSA, as Debbie said, will have one question on homelessness, and then the determination process happens sort of subsequent to that. So the FAFSA itself will have a question on homelessness, and the determination process is, happens subsequent to that. There's a great question about what if young people switch schools. Here the statute says that one of the authorized parties to make determinations is a financial aid administrator from a previous school. The statute also says that the status continues. But this to me is a perfect example of where it would be great to have guidance saying, yes, in fact, it does continue. And, you know, so that presumption for year to year continues. But I think it's actually a little bit of a gray area and something that we can, again, tee up for guidance potentially. Another question, would determinations be made by regular school counseling staff be permitted for this? The law says McKinney-Vento liaisons, but I think the more recent FAFSA and something we would work to clarify in guidance is that just similar to the homeless programs, the HUDR, RHYA, director or designee, so that we could have director or designees of liaisons as well, because obviously there's lots of young people and not very many liaisons. So that's a piece there. And then I'll try to take one last question before we continue on. And again, we'll have questions at the end as well, which is questions about provisional independent student status. Does this apply to students who live with parents but are estranged with them and refuse to provide tax information? Therefore, will a student qualify? I think the answer to that is maybe. As Debbie mentioned, the law kind of gives some of the specific unusual reasons that can be considered under the provisional independent student status. But again, it's very different than homeless and foster in that it is still subject to a school's rules around professional judgment. So I think the question there would be maybe, but there would be you know, more information that the student would have to provide, and it could very well qualify under this potentially. So that was a lot of questions I tried to answer as quickly as possible. We know we'll have more time at the end as well, and we can continue on with the second part of the presentation.
Great, and I do see a couple foster care specific questions in here that I'll just address real quickly. So one person is asking about a non-minor dependent, meaning a youth who's in extended foster care after the age of 18, and those youth also qualify for independent status. There's no different there as long as that youth was in foster care after the age of 13, which obviously they would be if they're 18 and they're currently in foster care, then that absolutely, they would also qualify for independent status. So I'm going to dive in now to some of the kind of broader issues that aren't necessarily specific to foster youth or homeless youth, but that will have an impact on homeless youth and foster youth as they complete the FAFSA that are part of these federal changes. So one of the things that the FAFSA Simplification Act does is there's this concept right now of estimated family contribution. That's being renamed as the Student Aid Index. It's really just a renaming. It doesn't fundamentally change what that is, but essentially what that is the amount of money that the campus has decided that the family or student themselves should pay towards their education. But estimated family contribution is sort of an outdated terminology, and so it's now going to be called the Student Aid Index. It also reduces the number of questions on the FAFSA a lot, so from 108 to 36, so hopefully that'll make it easier for all students to complete. It allows incarcerated individuals to receive federal financial aid so that we know, some of the young people that we work with do overlap with the criminal justice system, and so if they are in a situation where they're incarcerated and want to continue their education and that jail or prison has such a program, they can now receive federal financial aid to help cover those costs. It also eliminates a prohibition on students with drug offenses from receiving federal student aid. So again, we may have unaccompanied homeless youth and or foster youth who have in the past been convicted of certain drug offenses who were excluded from federal aid, and that will no longer be the case. They no longer have to, male students no longer have to register with the Selective Service, which is just a nice change. And it also simplifies the calculation for how the amount of federal aid will be determined. And that is expected to increase the number of students who are Pell Grant eligible. So if you have students who are maybe returning from the workforce or something like that, who are a little bit older, who have income and maybe had not qualified for Pell Grant in the past or had not qualified for the maximum Pell Grant, you may see some of that change. So they estimate that the number who receive a Pell Grant at all is going to go up by about 6 to 8%. And the share of those students who get the maximum Pell Grant amount is going to go up to about 81% from 64% currently. So I'm going to get into the weeds just a little bit. I'm going to go through this quickly, but just to sort of understand how the Pell Grant is going to be calculated moving forward. So if you're a non-tax filer, your income was low enough that you were not required to file a federal tax return, you will automatically get the maximum Pell Award. In addition, if you're an independent student, which most of the youth we're talking about here today, foster youth and homeless youth, are going to qualify as independent students who are a single parent, then if their adjusted gross income is below 225% of the poverty level, they automatically get the max Pell Grant. For an independent student who is not a single parent, their income would be below 175% of the poverty level. I'm going to show in a couple of slides kind of what the dollar amounts are, what that means. And those students who don't get the maximum Pell Award because their income is higher than that would receive the maximum award amount minus this student aid index amount that gets calculated based on their income. Go to the next slide. So students not receiving a Pell Award under either of these methods could receive the minimum Pell amount if their income falls below a set percentage of the poverty line. So, all of these calculations are really going to be very strictly based on what their income is and where that falls relative to the poverty line. The Pell Grant calculation now allows for a negative student aid index. So right now, the estimated family contribution, the EFC, only goes down to 0. And there's a lot of students with an EFC of 0. And so there's no way to distinguish between somebody who has like 0 income versus maybe somebody who has $10,000 worth of income. So by allowing for negative SAIs, the targeting can be a little bit deeper, which I think is going to benefit the students that we work with. And then the calculation will be based on the number in the household rather than the number in college, and students will be able to preview their Pell eligibility in advance. If we go to the next slide, this is just a quick look at what these poverty line guidelines are. So for example, if you're working with a single homeless student with independent status, in order to get the maximum Pell Award, their income would have to be below $22,330. If you're working with a mother with one child who's a single mom, then her income would need to be below $38,790 to qualify for maximum Pell. Some other changes, they did do an increase to the Pell Grant by $150, so it's going to be $6,495 next year. Removal of the 100% program length limit on federally subsidized student loans. We never like our students to have to take out loans, but on the other hand, a lot of times the students we work with maybe don't actually complete their programs in that 150% time limit. So if that's the case, they have one semester left to get their bachelor's degree and they've run out of financial aid, they will be able to at least get a loan to finish that off. Institutions can no longer have a blanket policy of denying all professional judgment requests. There's going to be more flexibility for financial aid offices to adjust income. So this is particularly important right now with so many students having lost their income and employment. Restoration of Pell Grant lifetime eligibility for students whose institution closed down. So this, a lot of these, in particular, some of these private for-profit institutions where they falsely certified as somebody is eligible for aid, or there was a lawsuit against them or something like that, those students are going to regain their access to financial aid. And then emergency financial aid that's given for a component of the cost of attendance, so that could be books or housing or food, will no longer be subtracted when determining the student's financial need. And last but not least, on my part, cost of attendance. There's going to be some changes that allows the Secretary of Education to more closely regulate the components of cost of attendance. And schools are going to have a food allowance that provides the equivalent of 3 meals a day, and separate on-campus housing allowances for students with and without dependents. And so we know that right now, a lot of times the cost of attendance doesn't really accurately reflect what the real costs are of going to college. So hopefully some of these changes will expand what's available for financial aid for some of the most neediest students like foster youth and homeless youth in the future. And I'm going to turn it over to Barbara.
Great, thanks, Debbie. So in terms of what happens next, we've sort of given you a sense of the effective dates. So you know that the October 1st, 2022 FAFSA is when these changes will first officially appear to go into effect for the 2023-2024 award year. But there are things that the U.S. Department of Education has to do in between that time. And the law gives the department the authority to do what it needs to do in order for an orderly implementation. So some of those things that are really quite relevant to our work. First is the Department of Education has to consult every year with stakeholders on the best practices for outreach, including outreach during the transition to the FAFSA. They also have to solicit public comments on the format of the FAFSA. And in addition to that, not less than 9 months after enactment, so that means before September, the Department of Education, 9 months before, 9 months, that would mean this September, so because it was enacted December 27th, the Department of Education has to do consumer testing. And the law lists some of the specific groups with whom the consumer testing must be done. And although it doesn't specifically name unaccompanied homeless youth and foster youth, it certainly names categories that they belong to: prospective first-generation college students and representatives of students, including low-income students, English learners, first generation, also institutions of higher ed, counselors, nonprofit consumer groups. So that consumer testing is going to be very, very important, particularly with fewer questions on the FAFSA, the single question on homelessness, and something that we will want to be involved in. The law also says that that has to be updated at least every 4 years. So we know that technology changes and we learn more about how young people and their people surrounding them are understanding the FAFSA. So that is good news as well. And I just want to say too, many of you may remember that we had a broader advocacy agenda, and we still do, around support for homeless and foster youth in higher education that went beyond the FAFSA. So what Congress did here is they just changed the FAFSA and the financial aid processes, parts of the Higher Education Act. They did not amend other sections of higher education. That was sort of punted, if you will, or saved for future Congresses, so they could just get through the FAFSA pieces. It was a very large priority for the previous chairman of the Help Committee, Senator Alexander, to change the FAFSA. So what that means is that this new Congress has work yet to do in higher education for the rest of the reauthorization, and our priorities are still the same as they have been around requirements for higher education liaisons for homeless and foster youth, housing priority and plans, voluntary questions about homeless foster status on applications for admission, improvements to TRIO and Gear Up. And then we know, just like every time we're engaged in practice and we see new barriers, of additional pieces of higher education law that we would like to amend. For example, the requirements around satisfactory academic progress, verification of non-filing, etc. So we put this in here just to let you know that there's still much more work to be done in terms of removing barriers and creating conditions for success for homeless and foster youth that the new Congress will have to take up. With that, I'm going to transition over to Jenny to talk about some other really important new higher education policies that are separate from FAFSA simplification.
Great, thanks so much, Barbara. Can we go to the next slide, please? And I think, Debbie, you're going to take this next one.
Yes, so just to mention that one of the other changes is that there's some money coming into the Higher Education Emergency Relief Fund. So you may recall that in the CARES Act, the first relief fund, There was $14 billion. Half of that had to go directly to students through their institutions. So if you, if you're involved in an institution, I'm sure you're aware that institutions were doling out some money to students for emergency relief, which was great. So there's more money that's coming to the institutions. So, we want to make sure that students who have been in foster care and are experiencing homelessness get access to some of these broader resources that are available for the general student population. So make sure you, keep in touch with your local campuses to understand what their distribution system is going to be for that money. There are some differences between what was made available last round, this round. One is that undocumented students or other students who aren't Pell eligible for reasons like satisfactory academic progress and such will be able to get access to these stimulus monies through their campus. Students who are enrolled exclusively online can receive funds. Campuses are required to prioritize students with exceptional need. With the CARES Act, they were only encouraged to do so. And the funding formula was adjusted a bit, so more funds are expected to go to community colleges. So keep your eyes out for when that money comes down so that our youth can get access. And if a student does have money that they owe to the campus can't just take the emergency money to pay an outstanding balance without the student's explicit written consent.
Thanks so much, Debbie. The next slide. And the next series of slides are a couple of provisions from the Consolidated Appropriations Act that might impact students you're working with that are in foster care or have experience in foster care. And the first is an increase of about $400 million of funds that many of you probably are aware of called Chafee funds, and tell you a little bit more about what you can use those for your, that students might be able to use them for. And an increase in that $400 million that at least $50 million has to be used for education and training vouchers for young people. And so this is a pretty big increase in funds. The current allocation for Chafee and ETV combined is about $180 million nationally. And so this almost doubles that allocation, which is really excellent. And that's a lot of money that will go through the states that should then be benefited, be of benefit to young people. Next slide, please. Thanks. And so these Chafee funds can be incredibly useful to students that you're working with. They're very, very flexible. They can be used, and they were really intended to be used to provide direct financial assistance to young people right now during the COVID-19 pandemic, but they can also be used for help with providing and paying for cost of housing, technology and Wi-Fi needs, other basic needs that young people have, and can also be used to help with child welfare agencies with just meeting these needs, doing outreach to young people, service, navigation, and other supports. Next slide. The law also made some adjustments to the current Chafee program so that states could serve more young people and be more flexible in how they're serving young people. And so Chafee eligibility right now for most states is until 21. Some states took the option to extend that eligibility to 23, that they would provide these Chafee aftercare services to young people who've been in foster care. And the new law allows states to serve you through their 26th year. So again, that really expands the number of young people who could get support and might expand, the students you're working with who maybe weren't eligible before the Consolidated Appropriations Act, but are going to be eligible for this period of time that the law is in effect. And I'll tell you about the timelines in a second. The other thing that the law changed that might be of use to some of your students is that the law formerly required that states could only use up to 30% of their Chafee funds for room and board, but that 30% cap was lifted, so states can use more funds to help young people who've aged out of foster care with costs related to housing and help them directly with paying for housing. The law also gives the states a lot of flexibility for their Chafee funds, so can provide for things related to kind of transportation and driving. So just a kind of new, not a new use of the funds, but one that a lot of young people really highlighted as an important use. Next slide. And then in terms of education and training vouchers, I'm sure many of you are aware of these funds that really do help young people who've been in foster care or are in foster care pay for the cost of higher education and training. The max award is currently $5,000, and this law changes that max temporarily to $12,000. It also makes adjustments in some of the requirements, so young people do not have to meet the enrollment requirement and the requirement to make satisfactory academic progress to be eligible for ETV. So that is one of those requirements that's waived during the pandemic, and youth are also eligible for ETV even if they attend less than full time. And the law also gives more flexibility in how ETV funds can be used. Next slide. Another provision of the law that may be helpful to some of the students you're working with is a provision that many people have referred to as the moratorium on aging out. And the moratorium really is just a provision of the federal law that says child welfare agencies can't end services to young people during the pandemic due to age. So young people who are hitting the age out age in their state, whether that be 18 or 21, if they want continued services, the child welfare agency needs to provide them. And that might be helpful for some of your students in providing stability and helping them stay connected to services. The law also requires all states to provide re-entry into foster care for young people who've aged out during the pandemic. So again, if you have students who aged out during the pandemic, and the law defines that as April 1, 2020, as that's the date of beginning, and then the law extends until September 30, 2021. This might be helpful in providing them a place to live in connection with services if they fit into this eligibility category. Next slide. And then another key provision in the Consolidated Appropriations Act that might impact some of your students is, many of you probably know the FYI program, Foster Youth to Independence program, the FUP program, Family Unification program, which provides housing choice vouchers both to families and to young people aging out. And in the Consolidated Appropriations Act, the Fostering Youth to Independence initiative did become law. And so the FYI program, which provides vouchers to young people as they're aging out, or if they are homeless but had experience in foster care, is now a permanent fixture of the statute, and some improvements were also made to the program. So currently the voucher lasts for 3 years. This allows a 2-year extension if young people are involved in the FSS program or kind of related work support programs. And so that really provides a great expansion of a really good program for young people. The law also opened up these vouchers to more jurisdictions. There were a couple of barriers currently that exist for housing authorities to apply for these vouchers, but right now, really in every housing authority across the country should be eligible to apply for these vouchers for young people. So this is really great because the law really made this program permanent, but also really expanded it. I put in the link in this slide, and you're going to get the copies of the slides. There's a couple of opportunities for vouchers, both non-competitive and competitive requests for proposals. So if this is something you're interested in, please check that out, and also contact any of us, any of the presenters, because this is really a great thing that is in the law, and hopefully will expand more housing options for young people.
All right, thank you so much, Barbara, Debbie, and Jenny, for sharing all this information. We do want to get time to answer questions live, but we just had this question for you all. If you want to answer on the chat portion, or respond on the questions on where you anticipate sticky issues in implementation that would benefit from strong federal guidance. You could also answer this question in the survey afterwards. But I'm going to go ahead and turn it over to Barbara to answer, and Jenny and Debbie to answer some of these questions that we have.
Great, I'll take a couple and then turn it over to Debbie and Jenny. So a couple that I thought to pull to answer there was a question, in practical terms, what's the intention of provisional independent student status? In other words, why wouldn't youth go through the unaccompanied homeless youth process? The intention, as I understand it, is to cover young people who are not experiencing homelessness, but who may have other reasons that prevent them from having access to parental information. So for example, students who were trafficked, students who were granted legal asylum, student whose parents are incarcerated. All those students may not be experiencing homelessness or be an unaccompanied homeless youth, but may face very similar barriers to accessing parental information. I will say this is probably one of my biggest areas of concern is the concern that young people who are homeless or from foster care will see this particular piece and end up going through professional judgment instead of just going through the unaccompanied homeless youth process. But I think the order of the FAFSA, and if the homeless questions come before this and the foster questions before this provisional status, that will help a lot. But that's my understanding of that. Another quick question to answer: if a student recently became homeless and the parents refuse to provide tax information, can the student be considered an independent student? Yes, if the student meets the definition of homelessness and also meets the definition of unaccompanied, meaning they're not living in the physical custody of a parent or guardian, then they are considered an independent student status, and that's current law. That's not prospective law. And I'll answer one more question, specifically homeless question, which is, please talk about the differences between these two. The first one being an unaccompanied homeless youth as defined by the higher ed statute, the College Cost Reduction and Access, and an unaccompanied self-supporting youth at risk of homelessness. So the difference between those two is, one, a youth who's currently experiencing homelessness and is unaccompanied, and the second one, the youth is at risk of homelessness, so they are not yet experiencing homelessness. The Department of Education and their guidance defines at risk as about to be homeless. So there's a very short definition. I'm just paraphrasing it there. But I think the point here is that with these changes to the FAFSA, the at risk of homelessness category is probably less important because we have unaccompanied homeless youth status continue for all their years in college. The purpose of having the at risk before was that we had youth who were unaccompanied homeless youth, but the next year they were technically housed, but they still faced all these barriers. So I think moving forward, the at risk of homelessness category will be, I don't want to say less important, but we'll have to use it less to make sure unaccompanied homeless youth get through that process. And I'm going to turn it over now to Debbie and Jenny for some of the foster care questions.
Hi, did you want me to pull out the foster care questions from the ones that have come in?
Sure, yep.
Okay. So one question early on was, for award of the court letter, should you be looking for one that states that the youth was 13 or 16? And I would say 13 if that's applicable, but note that for example, for the Chafee ETV program, it could be 16 that's required. So the best thing is to actually have a letter that shows the date of birth and the date the youth entered foster care, so that somebody can just do the math depending on what particular benefit they're trying to assess eligibility for, because the age might be different depending on the different benefits. Another question, so student who is 13 plus 1 day is qualified as an independent status. It's actually on their 13th birthday. So the day they turn 13, if they are in foster care on that day or any subsequent day, then they would qualify for independent status. Here's one question about who does the verification in a case where a foster youth is under the supervision of one state but lives in a different state. So I would say that probably getting I think there's probably some flexibility around that. And if you can get it from either state, the campus is likely to accept that. But the county that actually has, or the state that actually has supervision over the case is probably going to be the one that has access to the information. But you could probably go either way if you can get that information. There's a question about what's the best practice for a youth who's been in foster care beyond their 13th birthday. However, a foster parent has been claiming them on taxes. So independent status on the FAFSA is totally separate from taxes, totally different thing. So it doesn't matter if the foster parent was claiming them on their taxes. That's irrelevant in terms of the FAFSA. They can still get independent status on the FAFSA, even if somebody claimed them on their taxes after their 13th birthday. I see one California specific question that I'll just answer, which is, will these same changes be applied to the California DREAM Act application that we have for our undocumented students? And my answer is probably. That application mirrors the FAFSA, so I'm guessing that they will probably adjust it to align, but that will be up to the state.
Debbie, there's one on the Chafee max, and that's a per student max. That the max is up from 5,000 to 12,000 per student.
Right, and that's a temporary increase. That's not permanent. So it's just for this year and next year, and after that it would go back down to the current $5,000 cap. So there's a question here. I've worked with youth regarding Chafee. They often are denied Chafee, even though the governments, you know, they shouldn't be. I mean, this does vary by state. So states have really different eligibility requirements. And so like in California, if you were in care after 16 or between 16 and 18, you're under age 26, you haven't received the grant for 5 years, you qualify and you're enrolled at least half time, you qualify for the grant. But there are other states that have additional restrictions on who's eligible. You know, I would suggest that you consult with whatever entity manages the Chafee grant program in your state to better understand what's going on there. Here's one. A 17-year-old student lives with a grandparent, wants to file a FAFSA, but can't get the mother's 2019 tax info. What can she do? So right now, what she would need to do, I'm assuming she's not in like a legal guardianship or foster care, she would need to go to the financial aid office and request something that's called a dependency override, and provide documentation for why she should be an independent student and her parental income should not be included. The campus has a lot of discretion about whether to authorize that or not, but it's worth a try, trying to get that dependency override. I know it's a really difficult situation when a student ends up in a circumstance like that, but really all you can do is work with the financial aid office to figure out if there's a way to move forward with the FAFSA. I think those are most of the foster youth questions.
All right. Well, just a couple. A couple more that I saw that I will answer, and then we can turn over to resources. And again, please keep putting the questions in because we can respond afterwards in writing, even if we didn't get to the questions now. But just two real quick. Does the removal of the requirement for selective services apply to all students or only foster and homeless youth? It applies to all students, so that's a very good thing. And then also a question, since on the topic of college, who trains colleges on the McKinney-Vento Act? Are there McKinney-Vento liaisons as college? If not, how do we help these McKinney-Vento students pursue post-secondary education? There is not now a federal requirement for a higher education liaison. That is part of the advocacy strategy. It's part of legislation that's been introduced the last couple years and will be introduced again. I wanted to say, though, that some states have had state laws to have higher education liaisons for homeless and foster. So, for example, California, Tennessee, Maine. We have on our website, Schoolhouse Connection, on our state policy page, a list of states that have or are considering state laws to have higher education liaisons for homeless and foster youth. And with that, I'm going to turn it back over to Jillian.
All right, thank you all so much for sharing all this information. I just wanted to...
Can I just answer one other question I just noticed really quick?
Yes.
So I just noticed a question. somebody thinks that I said that undocumented youth can qualify for a Pell Grant under the CARES Act. That is not true. So just to clarify what I said, undocumented students can qualify for the emergency stimulus aid that will be made available through college campuses. Still are not able to apply for other federal financial aid to fill out a FAFSA to get a Pell Grant. So that's only for that one-time emergency aid that's coming through the stimulus bill. Thanks.
Right, thank you for clarifying that, Debbie. Just wanted to highlight a few resources. We have a dedicated FAFSA page. We also, that has our FAFSA report that analyzes 6 years of data for unaccompanied homeless youth, as well as the different challenges in COVID-19 era. We also have a few child welfare resources here too. And again, a copy of this PowerPoint is in the handouts as well as in the chat portion, a link as well. And so here are all of our contact information. Please feel free to send us questions, send us ideas, send us thoughts. We have a survey that will be sent out to you afterwards. And again, if you have any ideas of what are possible sticky implementation for you would like additional federal guidance, please include that as well. So again, thank you all so much for joining. We will be responding to a lot of these questions and we'll get those out to you at a later date. Thank you so much for joining.
Thank you.